Hi, everyone. We're going to try this again. So let's see. This is just, Okay, I'm going to wait a little bit, see if I can get some folks back in. If not, we're just going to do this the way we know how, because we know how to improvise here and work with what we got. So we'll see if we can try to get this started again. Facebook is not trying to let me be great. I don't know why, but we're going to get you this information one way or another. I can promise you that. So once you get in, just let me know you can hear me, and I'll get started with trying to get this live done so that we can talk about Daubert motions, how they work, and why they work the way they work. And then we'll figure something out as far as getting you the slides. So, all right. Let's start talking about Daubert motions. So before you can get to what a Daubert motion is, you got to figure out how expert testimony even comes in. And that's governed by 702. So what 702 tells us is that in order for an expert to testify, certain factors have to be met. Thanks, Anna, for letting me know. I don't know what's going on. I think something's wrong with Facebook Live. I'm not sure because it just kicked me out. It kicked out everything. But thanks, guys, for coming back in. And like I said, I'm going to get you the information. For those of you who are in the group, I'll post the PowerPoint slides in the group so that you can have it there. If you're not in the group and you want a copy of the slides, just DM me and we'll get you the information, because I really do want to get you guys this information. So let's try to get started. So with Daubert motions, the first thing you have to address is whether or not the expert can even testify. And that's governed by 702. 702 gives us specific requirements as to what the expert must be testifying to and why. So the first thing is that the expert is a witness who is qualified with experience, knowledge, skill, training, or education. And they are allowed to testify if the expert's scientific, technical, or other specialized knowledge will help the trier of fact understand an issue or determine the evidence, understand the evidence or determine a fact, an issue. The testimony has to be based on sufficient facts and data, and the testimony has to be the product of reliable principles and methods. This is where Daubert sits, in those two factors right there. And the expert has reliably applied those principles and methods to the facts of the case. So what does that mean to you? It means that first you have to understand 702 before you can even try to challenge expert testimony, because if you don't understand the framework and what they're required to do, then being able to challenge it just won't work. Then there is the fact that they must be qualified. But that first sentence where it talks about knowledge, skill, experience, training, or education, it's in the disjunctive. So it can be one of those 5 categories. It doesn't have to be all of them. So they can be experts based on their knowledge, based on their skill, based on their experience. A lot of times in my criminal days, not that I was a criminal, but I was a prosecutor, we qualified law enforcement officers based on their personal training and experience. That is something that can be done because of the way the rule is set up. Then the other key thing is that the testimony must help the trier of fact. An expert can't just testify because they're an expert and because they have nothing else to do. It has to help the trier of fact resolve an issue in some way, shape, or form, or at least go to an issue in some way, shape, or form. Remember, everything must be relevant. So it has to prove or disprove a material fact or consequence. So if this testimony doesn't go to anything that would help prove or disprove a fact or issue, then it's not relevant. And that's the basics for any expert testimony or any testimony, period, being admissible. So you want to make sure that it will help the trier of fact. If a fact is so basic and well known that the expert's testimony does nothing to enhance that issue, then the testimony is likely inadmissible. Now, the principles have to be applied to the facts of the case. So you can't have an expert that just opines on nothing or whatever it is they want to talk about that day. It has to apply to the facts of the case. Do they have to go fact by fact, issue by issue? No, of course not. But it can't just be so theoretical and so out there that it has nothing to do with your case. That's not going to be admissible. So once I understand 702, then I have to understand the Daubert factors. The Daubert factors, as I said, they kind of come out of the second and third prongs of 702. And there are 5 Daubert factors. They come out of the case of Daubert versus Merrill Dow Pharmaceuticals Incorporated. And the factors are: 1, whether the theory or technique in question can or and has been tested. So can I try what you're talking about? Can I test what you're talking about? And has it been tested? Or did you just concoct this out of nowhere? Then there's whether it has been subjected to peer review and publication. Have you submitted this to the journals, periodicals, and everything else? Has it been subjected to the review of other experts in the area? Has it been published, or is this just your secret recipe and your secret sauce that we're now going to talk about today? The known or potential error rate for the theory or technique is the third factor. We got to know how many times this theory fails. And for example, when it comes to fingerprinting or DNA testing, we know that DNA testing is accurate within like 1/1000% or something like that. And there are definitely set standards for how you do DNA testing, the 13 loci and everything else that needs to be done. The fourth factor is the existence and maintenance of standards controlling the operation of the technique. So what does that mean? Again, for example, DNA testing. There are federal standards in place that say what it is that needs to be done, which areas need to be tested, what the loci are, and think about the National Highway Safety Administration. They have specific rules and regulations in place and operations that say what needs to be the weight of a tractor trailer, when it needs to stop, how long the drivers need to drive. These are all things that there are standards controlling the operation of the test and technology that can be done. Whether the test or technique has been generally or widely accepted within a relevant scientific community. So back in the day, which isn't that long for Florida because we are always last to the party, Fry was the controlling standard. And that was just generally accepted scientific principles is really all you had to deal with. That still exists in the Daubert factors in this final prong, but it's not the sole thing that you now look at. And it's not the only factor that can either undo or redo solidify your analysis of Daubert. So these were the 5 factors that the Supreme Court created in Daubert versus Merrill Dow Pharmaceuticals for a standard for judges to apply in determining whether or not the testimony is reliable, not just relevant. So one of the things that has also happened is there were 2 cases after Daubert. One is General Electric versus Joyner. General Electric Company versus Joyner. There, the Supreme Court held that the testimony would be inadmissible if there was too large of an analytical gap between the expert's opinion and the principles that were relied upon, the underlying science. So if that gap is too great, then it's not going to be admissible. Then came Kumho Tires versus Carmichael. With Kumho Tire, what the court did was broadened Daubert to apply to experts who are testifying just on personal experience, not just scientific knowledge. So it now applied to essentially every expert. Daubert may not apply in every situation, but there are very, 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 very few situations where it will not apply. For the most part, it applies to anybody who's getting on that stand to testify as an expert, and giving opinion testimony for sure, because it makes sure that the judges are gatekeepers, that they become gatekeepers of the information, gatekeepers of the testimony. So once you understand 702 and you understand the Daubert factors, now you have to figure out, well, what the hell is a Daubert motion anyways? Well, it's a motion in limine, and it's a motion in limine to preclude expert testimony. The Daubert motion has to be made pre-trial. It's not one of those situations where, like with other motions in limine, I can make a decision as to whether or not I want to raise this issue at the beginning, or if I want to spring it on counsel in the middle of their questioning and watch their whole case fall apart. I can do that with some other issues, not with a Daubert motion. If you are going to challenge whether or not this expert is qualified to testify, you have to do that pre-trial, and you have to do that in accordance with the trial order. So most federal judges and state court judges have a trial order that tells you when the pre-trial motions have to be done by. If it says all pre-trial motions, your Daubert motion is included in that time frame, and you have to get it done and heard by then. Sometimes they'll separate out the Daubert motions because they'll do expert testimony or expert discovery separate from regular fact discovery. So just pay attention to your trial order and your schedule so that you can know when you have to do the motion. But it is a pre-trial motion that must be done ahead of time. A Daubert motion is also a motion that goes to the methodology, not the conclusion. Whether or not the expert is right is not the purpose of the Daubert motion. It's whether or not they actually have good scientific methodology that they're basing that opinion on. Whether or not they're right, that's your argument to the jury. That's not your argument to the judge. So you can very easily defeat a Daubert motion based just on that principle, that the motion goes to the conclusion and not the methodology. How do you know if it goes to the conclusion and not the methodology? Well, in Tanya's terms, it sounds like a lot of crying, like, oh, the expert is saying this and it just can't be right. Okay, you don't like it. That's how you know that that Daubert motion isn't solid. It's that you don't like what he's saying. It's not that he can't say what he's saying. That's different in that there is no solid foundation to what he's saying. That's a different standard, and that's what a Daubert motion really should go to, whether or not the expert is relying on scientific data, whether or not the expert is relying on proven data, on things that can be tested, that can be tried, and it's not just pulling something out of the air that, you know, this is what we're doing today. That's just not what we do. So that's what a Daubert motion is. It's a motion in limine to preclude the expert testimony because the methodology fails or the methodology is non-existent. So what's an example of non-existent methodology? I have a realtor who is going to testify as to the value of rental units in a building, but he's not an appraiser. He has no way to tell you that he has any scientific knowledge or basis on what it is that he is telling you. Now, do realtors try to do that all the time? Yes, they do, because they go by the market value. But guess what? That market value and how you arrive at that market value is done by methodology of someone else. So the realtor is not qualified to appraise the value of the property, which is what they're doing when they try to testify as to what this property should be valued at and what it's not. That's an appraiser. So that is challenging an expert based on their lack of knowledge. One of the things you also want to think about is what is their expertise? Okay, so let's talk about some tips that I have, first let me talk about how Daubert works. So how Daubert works is the judge becomes a gatekeeper for all the expert testimony and whether or not it should actually come in. What does that mean? What it means is, in the opinion, the Supreme Court established that the judge's role as gatekeeper is to screen the evidence and to ensure that the scientific testimony and evidence admitted is not just relevant, but reliable. So the judge has to make a factual determination as to each of the prongs in 702. That's what the judge has to do. So the judge has to make a determination as to whether or not the testimony will help the trier of fact. If the answer to that is no, then it shouldn't come in. The judge then has to make a determination as to whether or not the opinion is based on science and data. Then they have to make a determination as to whether or not the opinion is the basis of reliable principles and methods, and whether or not the witness is reliably applying those principles. So it's the 702 factors. Now, the thing is, this is a factual determination. What does that mean? That means it's an abuse of discretion standard. That is one of the hardest things to overcome, because the courts give large deference to the trial court judge as to whether or not this should happen and whether or not this testimony is admissible. Because that discretion is broad, you've got to do a lot of work on the front end in order to get this trial court judge to agree with you. Also, know that a hearing is not required on a Daubert motion. If your motion is so bare bones that it's vague and conclusory, no hearing is necessary. If your motion is not supported by deposition testimony, an expert report, professional articles, periodicals, or other materials that go to show that there is a significant issue with the testimony, a hearing is not necessary. What do I mean by a significant issue? It's if there is an issue concerning relevance and an issue concerning reliability. If your include anything independent that the judge can look at to determine that there is a significant issue, no hearing is needed. Most judges will avoid a hearing if they can, especially in federal court where they do everything on the papers. But if there is a significant question, then they will give you the opportunity to try to prove it up. But err on the fact that you're probably not getting a hearing, and make your motion as solid as you can so that the clerks, which is who we know really makes the decisions, can make a decision on your motion. So how do you do that? Well, a couple tips. The first one is know and understand the science. Here's the thing about these tips and Daubert motions. You have to set this up in depo. You have to set up whether or not this expert's testimony can even be challenged prior to when you can actually challenge it. So you need to set up the deposition and know what questions you need to ask during the deposition in order to be able to make the Daubert challenge. So how do I do that? The first thing is I need to know and understand the science. If I don't understand what this expert is talking about, I will have an uphill battle in the snow, both ways, barefooted, in order to challenge whether or not this expert's testimony is based on scientific evidence and data. So I need to understand it. I need to know that a myocardial infarction has nothing to do with fractions. You need to know and understand that the patella is not in your elbow. There are things that you have to have at least a basic understanding of in order to be able to challenge whether or not there's scientific data, and just to be able to have a conversation with this expert. Because a lot of experts pride themselves on the fact that you have no freaking clue what they're talking about. So they will go on and on and on in scientific terms in order to hope that you're thoroughly confused. Break it down. Make sure that it's plain. Make sure that you understand it. I always tell my participants about one of my favorite lines in the movie Philadelphia, where Denzel Washington would say over and over and over again, "Tell it to me like I'm a 3-year-old." It forces them to have to explain in layman's terms, whether they like it or not. But you want to make sure you understand the scientific terms so that you can make the proper challenge if necessary. Tip number 2, know the literature. What does that mean? You need to know what your expert has written on. What are their articles? What are their periodicals and journal submissions that they have where it deals with the issue that you have? Or have they never published on this issue? That would be kind of a red flag where you're talking about something you've never talked about before. So you want to know what this expert has published before. Find out what articles they published. Find out what they've done so that you can see if there are any contradictions during their depo testimony with things that they've said before. So I love Bull. I know it's not real. I know that jury science does not work the way it does in Bull, but I love it. And I was watching an old one a couple days ago because I'm so freaking far behind. And they were trying to disqualify an expert who they thought was going to testify on one thing. They scoured the earth literally and found an article that the expert had printed in Germany that said something opposite to what they thought she was about to say. Now, are we going to go search Germany for expert articles? No, not really, unless you have the resources to. If you have the resources to, scour the earth and find everything that you can, overturn every rock that you can, but you want to try to make sure that you look for everything. If you don't have those resources and you're a solo like myself, well, here's what you can do. Expert interrogatories. Ask them what their publications are. Ask them for every frickin' article they've ever written ever, what the names are, year published, publication or periodical that it was published in. Ask them that information so you can go look it up and you can figure out what their articles are and what they've been saying before. The next thing is know your judge. Every judge is different. Every judge in the Southern District is different, and that's just one district. Forget all across the country. So there are judges that are very welcoming to Daubert motions, and they actually grant them sometimes. Know your judge. Research whether or not they have a tendency to grant the motions or not. Does it mean you don't file the motion? Not if you have good grounds to file it. You file it, and then it's another thing that you might have to challenge on appeal. But know your judge. Know who you're talking to, and know what grounds they will preclude expert testimony on and which ones they won't. That'll save you a lot of time. Then know what your judge knows. So the judges get a book, the federal judges do, get a book called the Reference Manual on Scientific Evidence. That manual has reference guides published by experts in the field, and they are experts. It's just, I'm always puzzled as to how they picked those particular people. But they're published by experts in the field, and they're reference guides on different topics, scientific topics. And when you go to the Federal Judicial Commission page, and I'll put the link actually in the comments for you guys. Let me do that now so that you can have it. fjc.gov. The reference manual also, it's supposed to help judges make decisions. When you go to the page, you'll see that it says it's supposed to help judges make decisions on complex scientific issues. This is what they are relying on and referring to when you raise your objection to an expert and when they're trying to figure out whether or not the expert testimony should be precluded. So if this is what they're relying on, you should use it to see if you can learn anything from it, depending on what it is your issue is. Now, it's free. There's a free PDF that you can download, and you can have the manual, or you can pay for the bound version, which is what the judges get, but there's no difference between the bound version and the PDF copy. It's just, you're literally just paying for the cover and the printing. So it's a free PDF, but the manual is something that they use in order to figure out, how the science works. So you can use that as a guide where you can try to figure out, at least the basis of what the judge is going to be looking at when they're trying to figure out how the science works. The other thing, after you know and understand the science, the literature, your judge, and what your judge knows, know their association. Every expert is part of a professional association or professional organization. Each of these organizations have standards for the most part. Well, figure out if the expert is deviating from these standards without good reason. That can be grounds for a Daubert challenge. Because why? Why is it that the NTSA would say one thing as far as how things should be measured and how things should be treated, and this expert is doing something different? So you want to know what their associations stand for, what the principles are, what the standards are, what the regulations are, and make sure that expert is sticking to those regulations. And if they're not, figure out why and whether or not you can use that to make a Daubert challenge. The other thing, know the absolutes. So the only people that give us a run for our money when it comes to it depends are scientists. There are few, if any, absolutes in science. So if your expert is talking in absolute certainties, that's a red flag. And you want to figure out how they can be absolutely certain, and why they can be absolutely certain, and whether or not if it's even possible to be scientifically absolutely certain. Most experts should avoid absolute certainties, and if they're not, you want to look into that and see what is going on. Then know the factors. So Daubert has 5 factors. You might not need all of them. Deal with the ones that apply to your case. So for example, everybody who tries to attack qualifications, sometimes that fails because 99.9% of the time, this person's qualified. They've done the schooling, they've done whatever education requirements they need to do. The question is whether or not they're qualified in this particular issue. So remember the realtor who's not an appraiser? That can be where you challenge qualifications and knowledge. You're really challenging knowledge and skill at that point, and education, because here they're not qualified to be an appraiser. So I think what happens is a lot of people mistake qualifications for education. This person's educated. That's not your issue. The question is whether or not they're qualified in that particular area of expertise. So one time I saw a trial where the plaintiff's attorney had a therapist on the stand. She's a mental health therapist to testify as an expert. All he did was ask her what she does for a living. She said she's a licensed therapist, and rightfully so, defense counsel objected and said, because he tried to tender her as an expert, which you don't have to do, and you're probably not supposed to do in some jurisdictions because it's thought of as commenting on the qualifications of the witness. But he tried to qualify her as an expert. Defense counsel objected, and the judge's response was, I don't see the problem. She said she's a therapist. Well, what does that have to do with anything? So first of all, there's no scientific field of therapy, meaning there are mental health therapists that do a ton of different things. You have behavior modification specialists, you have addiction specialists, family and marriage therapists. There's so many different areas within therapy that just qualifying the person as a therapist is not enough. So you want to make sure that this person is being qualified in the particular expertise area. If they're qualified for brain injury, they can't talk about your heart. Like, yes, there are doctors like lawyers where we have to have general information and general knowledge of a number of things. But if you're qualifying me as an expert, it has to be what I do all the time. It has to be what I understand, what I'm certified for, what I know and understand better than anything else for the most part. So you want to know what your factors are and make sure that you are attacking the factors that matter, because all of them might not be applicable. So you want to make sure that when you're doing that, you don't lose credibility with your judge because you took the shotgun approach. Be detailed, be thorough, be purposed, and it also helps you narrow your issues in your motion so that you can have the right support of the deposition testimony, the periodical materials, and things like that that you need in order to attack the motion. So I hope this has been helpful to you guys. If you have any questions, please feel free to reach out. I will definitely answer whatever questions I can. And I look forward to seeing you again next month for our next Lunch and Learn. Have a great day and stay safe wherever you are. Thank you.